Objections are based on the rules of evidence, and nowhere in the rules of evidence does it allow for lying as a basis for an objection. Some of the common objections that I see most often in court are relevance, hearsay, and beyond the scope. Relevance means that it is related to the issue or issues in the case. In law school, my evidence professor talked about relevance as a brick in a wall. The evidence does not have to be the whole wall in order to be relevant, right? But it does have to be a brick. It has to fit into the wall. It has to have something to do with building this wall. The next objection is hearsay. Hearsay is incredibly complicated, and I'm not going to get into all the details because there's tons of exceptions and exceptions on exceptions. Generally, it is defined as an out of court statement. So, something someone said outside of court that the witness is trying to use in court to prove that what they said was true. The only people you can quote in court are the other parties, and that's based on an exception to hearsay about admissions by party opponents. There are other exceptions about child hearsay, and I'll maybe make another video about that one day. But if you hear someone say, he said, and that person is not a party to the case, objection, hearsay. Hearsay is based on the confrontation clause, which says that anyone who's being accused of something has a right to confront their accuser and question them about the accusations. You cannot say so and so said this guy's a bad guy unless you have so and so there to testify so that that quote unquote bad guy can cross examine so and so and confront them about the accusation. Then the last objection I mentioned was outside the scope. If you are cross examining someone who just testified, the only thing you can ask them about are things that they just testified to. You can't pull things out of nowhere and ask them about that unless you call them as your own witness and do a direct examination of them. So what do you do if someone's lying, right? You can't objection lying, but what you can do is called impeachment, using a prior inconsistent statement against them in court. By definition, technically, it has to be something they said under oath. If they said something under oath in a deposition, and then now they're under oath again saying something different, you can use their contradictory deposition statement to impeach the witness. Now their credibility is completely called into question. Now the judge has to take that into consideration in determining whether or not you are telling the truth about everything. Let's talk about perjury, okay? These people are perjuring themselves if they're lying in court, technically, right? I've been practicing for 8 years in family law. I have not once seen someone penalized, criminalized, arrested, charged, anything with perjury. The biggest consequence that I have ever seen in court for lying is impeachment, which means that nothing you say is going to be believed after you're impeached. That's a pretty big consequence if you're trying to prove a case. If you're impeached, it's really hard to win your case because then the judge doesn't believe anything you say. That's how you deal with someone who's lying in court. I hope that helps. I also just wanted to add that people will lie in court, so it's important to prepare for it, expect it, and be ready with impeachment evidence.